Three laws that stand out in this case study include the Basic Conditions of Employment Act 75 of 1997, the Unemployment Insurance Act 63 of 2001, and the Labor Relations Act 66 of 1995. All of them are applicable to the case and are inversely linked to each other. The Constitution is also referenced and relevant, especially in the Basic Conditions of Employment Act and the Labor Relations Act. These acts can therefore not be solely applied, also not only in this particular case but other cases as well. The Basic Conditions of Employment Act 75 of 1997. The basic provisions of this particular act are underpinned specifically by health and safety of the employee. In this case study, that of the pregnant employee. At face value, one would have thought that the employee had a right to dismiss the employee or rather place her on an extended leave of absence purely based on the risk to the unborn baby, and that would have made some sort of sense, and it would also appear to be the safest measure to undertake, and this would have indefinitely protected the employer and exonerate him from causing harm to the unborn baby. However, the rights of the employee would clearly be infringed based on her pregnancy, and that purely amounts to discrimination, which contravenes her constitutional right to reproduction. The law clearly stipulates the legal obligation that the employer has with regards to special circumstances affecting different employees, and it is clear from this assertion that absence of such registration would have resulted in lots of worker exploitations and the resultant unfair dismissals. What came out new in my learning experience is the responsibility placed on the employer in ensuring that alternative employment is provided on the same terms as the original agreement. One would have thought that since the employer is providing an alternative, then he reserved the right to do so at a reduced salary or remuneration. However, the law protects employee unless if it's not practical for the employer to do so. The codes of good practice further enhance the learning experience, once again re-emphasizing the responsibility placed on employers as such, and aligning this with the Occupational Health and Safety Act 85 of 1993 and the Mine and Health and Safety Act 27 of 1996, emphasizing conduction of health risk assessments. If this was not done in this particular case, both the employer and the employee would have turned oblivion to risk with resultant detrimental effects to both of them. Now let's look at the Unemployment Insurance Act 63 of 2001. Although one was quite familiar with this piece of legislation, what came out new was the period within which a contributor should have been working to access maternity benefits, which is 13 weeks. If this employee had been falling out of the said 13 weeks, she wouldn't be able to access the maternity benefits. What also stood out for me was the relation between COIDA and the said maternity benefits. If the employee was unfortunate to suffer an occupational disease whilst pregnant and receive compensation for the disease, this would have excluded her from the said maternity benefits. Labor Relations Act 66 of 1995. This case also provided a learning opportunity in Labor Relations Act, specifically concerning dismissals, unfair labor practice and discrimination, and how it then tallies with the Constitution. What came out new was the fact that the dismissal in this case was deemed automatically unfair, with the employer clearly contravening the law. Even if this dismissal was deemed to be due to incapacity due to a pregnancy, neither does it fall within ill health or poor performance. The employee, in this case, is not ill but pregnant and still able to carry out her duties. The issue is the hazard to the unborn child. It is therefore pertinent that the employers familiarize themselves with the Act concerning types of dismissals. In summary, one has learned the effective application of all these pieces of legislation in unison as they do relate to each other. Thank you.